Carol Beaumont.
Thank you, Mr Speaker. Mr Speaker, so going back to the issues around the protocol, the Civil Aviation Cape Town Convention and the aircraft protocol that goes with that, I want to talk a little more about that here in the second reading. The protocol, as I said, relates to aircraft which carry at least 8 people and helicopters carrying 5 or more. And the treaty resulted from a diplomatic conference held in Cape Town in South Africa in 2001, as the name would suggest. Attended, I thought people would be interested in knowing a little more about the conference. The conference was attended by 68 countries and 14 international organisations. 53 countries have signed the resolution proposing the treaty. The convention portion of the treaty came into force on the 1st of April. Gee, that's a bad date for conventions to come into force, isn't it? 1st of April 2004, and has been signed by 28 countries. And the protocol, which is the bit that specifically applies to aircraft and aircraft engines, took effect on March the 1st, 2006, when it was ratified by 8 countries: Ethiopia, Ireland, Malaysia, Nigeria, Oman, Panama, Pakistan and the United States. And in the US, the treaty was approved by the Senate in 2003 and implemented by the full Congress in the Cape Town Treaty Implementation Act of 2004. Just the other dimension, the registry of mobile assets that's been set up under this convention to establish the record of international property interests in the equipment covered by the treaty is indeed located in Ireland. And in fact, mediation cases for leasing disputes are to be heard in the High Court of Ireland. So that's just a bit of background there. When you look at the bill itself, what you see is that the overwhelming portion of this bill, this document, is in fact the convention and protocol which are appended to it in schedules. So we've got the full text of the Civil Aviation Cape Town Convention, and the aircraft protocol that I've just referred to are appended to this bill. Now, there are a couple of things that I'd like to just cover off on. The first is the Civil Aviation Authority itself, which has indeed operates in an international system, hence the need for conventions like this. Civil aviation, as they say in their annual report, is an international system, and in fact they work within the framework set by the International Civil Aviation Organisation. That as a contracting state within the International Civil Aviation Organisation, New Zealand does have responsibility to comply with the standards set by that organisation. And they have a number of effects. And interestingly, in relation to the points just made by the Green member, the other strategic objectives, so it has a series of objectives for 2010 focused on enhancing global aviation safety and security. It goes on to say that other strategic objectives include minimising the adverse effects on aviation on the environment, in particular aircraft noise and aircraft engine emissions. So I think there is an awareness of the problem, and it is an issue for a country like New Zealand where we are indeed reliant on aviation, and we are a country a long way from markets that we trade with, and indeed we are a country of destination for tourists from all around the world, and so we are indeed highly reliant on aviation to bring people to this country and to get our products to market. And Mr Bennett, the chair of the Transport and Industrial Relations Select Committee, was noting that indeed there's another important role, and that is in fact we do export in the aviation area. We export, and I was interested to hear him talk about that matter because my late father Ron, actually worked at Hamilton Airport. He was a mechanic, but he went on to get his trade certificate in aircraft engineering and worked there producing aircraft which were top-dressing aircraft, and those in fact were world-leading aircraft. So I just thought it was interesting that Mr Bennett had noted that that is probably a small but important part of our manufacturing exports. Talking of the Transport and Industrial Relations Select Committee, I would like to join with my colleague Darian Fenton, and she took the words right out of my mouth really, that I too had meant to wish a speedy recovery to our fellow Select Committee member, Mr Tau Henare, who is, as we all know, unwell at the moment, and I do wish him a speedy recovery. And while I'm talking about a fellow member of the Select Committee, he is in the interesting position, of course, of having his own members' bill before the Select Committee. And that bill is an interesting one. It is also in relation to employment rights. And we had talked in the first reading about the fact that New Zealand is a country that takes international obligations very seriously. We do feel it's important to sign up to relevant conventions and to play a good role in the international community in regard to many areas. And in fact, we've often been in a world-leading role, and certainly that is the case in terms of international labour standards, where New Zealand played a founding role in the International Labour Organisation. We have a proud history in that organisation, and one where in any given International Labour Conference, which is an annual process and it's going on at the moment, in fact, often New Zealand will have people who end up chairing committees or involved in drafting committees, and we are seen as a country that takes these matters seriously. And so it is a bit of a shame that the bill, the Employment Relations Workers Secret Ballot for Strikes Amendment Bill, is one that I think perhaps will see us going in the reverse direction than one we would want to in terms of workers' rights. So, yes, indeed, conventions, and whether that will have the effect of meaning that we come up against what would be seen as international best practice remains to be seen. But getting back to the Civil Aviation Cape Town Convention and Other Matters Amendment Bill, as I was saying before, that the full text of the convention is a schedule to this bill, and I don't want to go through this, you'll be pleased to know, article by article, but I would just, because there's a desire for that, perhaps I'll just tell you what the respective articles are, not read them out to you, given it runs to many, many pages. But in due deference to my colleague from the Māori Party, let me just say that this has a flavour of it. So Article 1 is the definitions, and that goes to several pages, as you can imagine. Article 2, the international interest, which provides for the constitution and effects of an international interest in certain categories of mobile equipment and associated rights. Article 3, the sphere of application. Article 4, where the debtor is situated. Article 5, interpretation and applicable law. Article 6, the relationship between the convention and the protocol. Article 7, the formal requirements. Article 8, the remedies of chargee. So as you can see, this does go through a range of articles, right through to Article 39, 40, 54. Perhaps I won't go through the rest of them for the people in the House. But seriously, these are important matters which will streamline and standardise processes internationally, and which hopefully will have an effect that means that there is greater certainty for those that are financing aircraft, that makes sure that instead of a wide range of different domestic legislation applying, that we will have standards, that it will be simpler to use the registry located in Ireland to identify what the status of ownership or whatever of a particular aircraft is, and I'm sure that we're all pleased to know that any disputes will be dealt with in the court system in Ireland, which I'm sure is a very robust one. So for my contribution for the second reading, I'll leave it there and look forward to further comment in the third reading.